And supply lunch for everybody?
There's always one in the group, Mr. Potter. Not today. That's the next webinar. All right. So there are a couple things I want to just make sure everyone is aware of as we get started today. And I just want to make sure this is going right. Yeah, okay. All right. So a few things for you to keep in mind. First of all, obviously, there are just a couple things going on as it relates to overtime and non-compete regulations. We're going to get into all of it in a minute. If you have your cell phone, you will want to keep that handy because we're going to be doing some live polling to get everybody to share their thoughts or what they're thinking as we go through this fun stuff. And oh, but wait, there's more. If you have additional questions, you are more than welcome to either put it in the chat or unmute yourself and ask your question. Now, bear in mind, I'm trying to be mindful to everyone's time, whatever time zone you may be in. In the East, of course, it's noon. And so my goal is to make sure that by the time we hit 1 o'clock, we're good to go. But if you have questions and I haven't gotten to them, I'm happy to cover them when we're all done today. So don't worry, I will get to your questions. And if there's anything else that comes up, certainly we'll deal with it as we go. And with that, I will get started. First of all, thank you for joining me today. I am really excited, sort of, to be doing this simply because there's been nothing going on. And the interesting part, by the way, is if you were paying attention when these things first dropped, it seemed like they all dropped at once. And I'll explain in a few minutes why that's been a bit of a challenge as we sort of go through the fun and games we're dealing with here today. Now, let's be very clear. You may have already received an alert either from Brown & Connery or from another law firm telling you what the parameters are like, either for the federal overtime regulation changes or the non-compete regulatory changes. Here's what we're not going to do. I'm not going to just be sitting here providing you with just one or two things and saying, hey, keep this in mind. No. I want to delve deeper. That's why I put this together. I want to sort of think about, all right, if this is what they're suggesting, why is it? And now, what do you need to do about it? So that's really the purpose of today, to try and help you, arm you with a couple of things to think about, independent of whatever else may happen. Because if you're like me and some of our clients, I know that you may be a little bit gun shy. You may be thinking to yourself, I remember the last time, this is not my first rodeo, and the last time we went down this road, 48 hours before, for example, the overtime stuff was supposed to go into effect, everybody ran around like crazy chickens trying to get stuff done, and then bam, what happened? A federal judge in Texas decided to say, I don't think so. But there are some other things you need to be aware of, despite the fact that you may be a little bit twitchy from the last time we were here. Now, before we ever get there, there are two other things I want to make sure that you're aware of. Number one, for those of you who are SHRM certified, this will qualify for one PDC, and I will explain to you later how you can get that PDC code. The second thing is this. I don't want you necessarily to worry about all the different slides that I'm showing you. I'm going to make sure that I provide you the slides later. I'll explain to you how. And in fact, I'm always trying to get better. For those of you who have ever seen me speak before, I'm always trying to level up what I provide as well as the presentation that I give. So I will ask later on for some feedback from you, but we'll get there. Don't worry. So don't worry about trying to jot down every single little thing. If there are certain components, of course, feel free to write that down, but don't worry. I will make sure that you get the deck. One of the things to notice behind me, of course, is the fact that, and my head's slightly in the way, so let me move a little bit. You'll notice it does say as of today. The reason for that is because all of this stuff is subject to change. So it's what we know today versus what may occur between now and the time that things may change. There are a couple of dates, of course, we're going to be covering, along with some other concerns as we go through our time together today. Now, I mentioned before this idea of, there should be a way to do that. I just don't know what it is. All right. One of the things to keep in mind is that I want to make sure we can all share together, which means I want to make sure everyone can do that. And so to do that, what we're going to do today is a little live polling. So please, how did that, well, we skipped that. Huh. Oh, I know why. My bad. There are a couple of things I want you to keep in mind today. The very first thing is this. There are three issues that permeate both of the regulations we're going to talk about today. And when you think about it within your own organization, what you want to think about it as is almost three spheres that work together. When you think about it, we're going to be dealing with a couple of different areas. On the one hand, we're going to look at calculations. And obviously, when we talk about overtime, that's pretty simple, right? What's the hourly rate? What do they have to do? What's the threshold? That kind of stuff. But it's more than that, because we also have to think about the documents we need. We've got to think about how the changes are going to occur, for example, to non-compete agreements. What does that do to the bottom line? When we talk about culture, what I'm talking about is some of the soft skills, particularly those of you who are in HR probably appreciate this idea of, you know what? We have to be thinking about morale. We have to be concerned about transparency and how are we communicating to our employees. And I'll be going through some of that because let's be honest, what we're talking about today is not core to your business. That's why you're spending time with me today. So we'll be covering some of that. And then, of course, that last minor thing, the competitiveness concern, meaning if we can't do non-competes in the traditional sense, what do we do? If we're concerned about how we address overtime and the escalator keeps going up, now what? Those are just some of the things we're going to deal with as it relates to competitiveness. So keep those things in mind as we go through our time today. While we're at it, let's make sure we can all get the opportunity to share together. What I'd love for you to do, please take out your phone and text to 22333. No, you don't need the dash. And then what you want to do is message in the message, put in Louis Lessig 726. What you should get back is from Poll Everywhere to let you know that you have joined our session today. Give everybody a second to do that. And the cool part here is it doesn't matter where you are around the country because we have the opportunity to all engage at the same time. All right. I'm going to make the assumption that everybody has predominantly gotten in. So let's see where we go from here. I want to start off by trying to ask something that hopefully is somewhat of a softball question, if you will. I'm curious, as you come into today, how do you feel about these regulations, particularly related to overtime and non-compete provisions? Are you happy about it? Are you a little scared? Are you angry? Maybe you're a little thinking something else. Whichever letter is most appropriate for you, clearly you figured it out. You know, one of the interesting things about all this stuff is we only have a certain amount of control. And that's really why I asked this first, to appreciate and understand how you're viewing it right now. There's a lot of ways that we can look at this stuff. And for those of you who are in the SHRM world, you realize that right now SHRM is talking about 1 million civil conversations. I think this slide goes to that as well. This idea that what we're trying to do is make sure that we can find that middle of the road. And there's a lot of education that needs to take place in this space, which is why we start here and then go from there. Now, at times, you may think to yourself, well, I'm not really sure what is going on. And so I want to sort of pressure test what you're trying to get out of today. And so I'm kind of curious. Please let me know what the kinds of things are of most concern to you today. And while you're thinking about that, look at it this way. The overtime regulations were like 300 and some pages. The non-compete provisions were 570 some pages. You didn't have to read any of that. I'm going to distill it all for you and what it means in like 45 minutes. How cool is that? I appreciate you sharing. It's very helpful to me, as I said. We will work on making sure that we cover all this stuff for you today. All right. Let me also ask whether or not any of you have taken the time to already start as it relates to the overtime changes, if you've started to take a look at that within your organization. And there's no, you know, this is not like Big Brother. So I'm just kind of curious in terms of the audience and what you're doing right now. some of what I would have anticipated. Okay, cool. All right. So let's hop right into it, my friends. You know, the one thing that we have to appreciate is there's a multitude of components, as we all know, when we start talking about overtime. And it's really the balance of the three different things we have to do. It's important that we start there because we have to recognize, well, there's a couple different ways to attack this, right? I mean, in essence, the challenge is we're talking at this point about that salary level and trying to assess how we move forward. And it's interesting the way in which the Department of Labor has approached this. And there's a lot of reasons why that becomes important, not the least of which is consider who gets covered, right? Because when we talk about who a worker is as it relates to these regs, we're talking about your employees, your independent contractors. We're talking about your interns. I know this is the time of year everybody loves hearing about that, or even externs or volunteers or apprentices. And so the impact cannot be understated, or rather overstated, as it relates to these concerns. It gets even more interesting when we start delving into some of the more specifics. So what this really covers. Now, we start with the idea when from a perspective of impact, we have to appreciate the different areas that get covered. And I will apologize now for those of you that deal with this all the time, but just for completeness sake, okay? Obviously, we're talking about the exemptions. We start with the executive exemption. This idea that the primary duty's got to be managing the actual, enterprise or organization itself. You got to have the ability to hire and fire. You have to have at least two folks that you manage, and the level of control that may exist. Oh, but wait, there's more, because it's not just the executives. It's also dealing with the administrative exemption. And of course, we could go down that rabbit hole for some time. As we all know, there are certain titles, for example, even in HR, where some people would be considered administrative and some are not and would be considered hourly or overtime eligible. Don't worry, we'll get to more of that in a minute. But the idea that, the primary duty is office or non-manual labor, directly impacting the management or general business operations, either of your organization or of your clients. Now, those, from my perspective, these are sort of the basics, right? And it's important to appreciate where we are because these are just two. Then we get to an area that doesn't necessarily impact everybody. Because when we start talking about the professionals, now we're talking about lawyers, doctors, teachers, those kinds of folks, which you may or may not have a whole lot of, all right? But then we get into those folks which are also specifically covered in this group, highly compensated employees. Now, when we talk about our highly compensated employees, the distinction, of course, is they get that threshold dollar amount by the end of the year, right? Currently sitting at a little north of $107,000. But wait, there's more, because they also have to do what? They've also got to be doing office non-manual or labor and have at least one of the other duties that they do. Now, sometimes that can be challenging. We all know that there was a Supreme Court case with an oil rig worker and whether that was appropriate in terms of how he was paid as a highly compensated employee. Of course, in that case, the Supreme Court came down and said, well, actually, it's not about whether or not he was doing the exempt duties for a highly compensated employee. The issue was you can't calculate it based on a daily rate. It's a weekly rate. Interesting, but far afield from what we're talking about today. So this, of course, begs a very interesting question that I have to ask everybody, which is another reason why we're doing some polling. So please humor me if you would. When was the last time you did a classification analysis within your own workforce? And of course, all right, so I figured that there'd be some question here. When we talk about a classification analysis, now we're talking about the different areas, whether it's an executive exemption, an administrative exemption, a learner professional exemption, and where your folks may fall as to whether they're overtime eligible or whether they're a salaried employee in the DOL assessment of that. Now, for those of you who have joined the It's Been a Minute, let's be real clear. This is the area independent of anything else that happens, you need to spend time on. I can't tell you the number of situations we're currently dealing with for clients where we're taking a look at these issues, because like the misclassification concern around independent contractors, this is a big area and a very large area of emphasis for the Department of Labor. Because of course, if you're not classifying them the right way, it almost doesn't matter. They're likely to be overtime eligible, which would create a whole other ball of wax and all sorts more fun for you. So that being said, what's not included? And I think it's also relevant to note, because you probably have some of these folks working for you right now who are otherwise classified as something else. For example, your computer professionals. Now, let's be fair. This is not that help desk person that you go to when you're like, oh my God, where is the delete button? I can't find it, right? And it's also not that person that you call at the help desk. These are the people that talk about architecture, and they're not talking about the baseboards or, the crown molding, okay? These are the folks that are designing the server farms and the way in which things work, right? They have their own hourly rate. That is not changing as a part of these proposed alterations. Similarly, outside salespeople, their provisions have not changed at all. I would argue the biggest thing, and I'm not even going to ask right now because I know that some of you do have California operations, but unless you're in California, for the most part, the cool part is there is no change to the duties test for any of the areas that I've already talked about, which is, from my perspective, a big deal, and for you, also a big deal. Now, that's just part of the fun and games we get to deal with here, because we also have to appreciate the fact that at the end of the day, I don't know about you. See, I tell people my undergrad's actually in HR, and I don't hide it. One of the reasons why I picked HR was because at the time, there was no math involved. And now, what am I doing? Math. So let's just deal with it. All right. Let's talk about where we are right now in terms of the salary threshold, okay? Currently, we're at that 684 number. This is sort of where we've been for a little bit, and it's been fine, not a big deal. There are some things, though, that you should appreciate about this. The first is this. It's set on the 20th lowest region, which currently is in the South. And that's it, right? The reason why we're back doing this through the regulatory process is because the number was set at that 684 level, and the only way to change it is to come back like we are right now. Now, that would be fine, except the initial step is still based on that 20th percentile number. The idea, of course, is that it's going to change effective July 1st from the 684 to 844 or 43,888 a year. I know what you're thinking. Really? But here's where life gets interesting. It's not actually in July. The real fun and games happens in January, because in January it goes up yet again, and not based on the same regional characterization. DOL wants to reset it so that it's now the 35th percentile. Now, mind you, that's still going to be in the South, but that extra movement of 15 points makes a big difference. Let me put this in perspective. So going from where we are at 684 to the 844 is an increase of some 22%. Then on top of the 22%, going from July to January, we're talking about another more than 33%. That's going up some 55% in essence, 6 months, which is kind of a big deal. Now, I'm not sure about your organization, but it gets even more concerning when we consider the evolution of how this works. And I'll get to that in a sec, because it's not, this is now for your run-of-the-mill folks that are currently overtime eligible. But remember, we also have to deal with the highly compensated employees. Currently, they're sitting at 107,432. When we make the alteration, okay, they're in the 80th percentile. Not a problem, okay? But the new number that's going to get set for them is sitting at 132, effective July 1st. In addition to that, we also have to deal with this. because like the regular overtime threshold, the highly compensated employees is also going to change. So come January of 2025, wait for it. That's right. We're going up to 151,000, and it's not going to be the 80th percentile. It's going to be the 85th percentile. Now, when we think about that, we're talking about going from where we are now to July, we're going up some 23+%. Then from there until January, we're going up at least another 13%. Are we having fun yet? All right. Well, let me see if I can impress you even more and explain to you why what the Department of Labor is doing is going to impact every single organization and your bottom line, and why you've got to address this stuff right now. And for the 60% of you that have already started looking at this, you may appreciate this already, but for the rest of you, check this out. And by the way, just remember one thing, don't shoot the messenger, okay? Because I'm here to help, and I'm just, like I said, I'm just running the numbers for you. So let's talk about how we're going to be doing this. If you think about it, where are we right now? And again, we have to take certain types of projections in an educated guess. Currently, for example, in the public sector, there are certain caps. For example, here in New Jersey, where I'm based, public entities can't go up in their amount of taxation more than 2%, absent some other things going on. So let's take that 2%, okay? Now, you may have noticed that on both the highly compensated employees slide as well as the regular salary overtime slide, both said as of January, it's going to be reset every 3 years. So let's take a look at that. If you're looking at this, we're going to start in July of this year, or well, in July of 27, okay? So it's going to stay the same from January of 25 until July of 27. Then it's going to get reset. Now, here's where life gets interesting. If we presume 2% every year, right? So, and we pull that through, here's where we get to. In 27, this would be the new number. If we pull it through again to 30, so we're now at 2030, here's where we would be, assuming it was a 2% per year number. By the way, what the regulations talk about is that the federal government will reset based on cost of living at the time. So I'm not suggesting it's definitely going to be the 2% a year, but it's a reasonable, guess or estimate, if you will. Then let's say you have a 10-year plan. If we go from 2030 to 2033, here's where we could be standing. Now, I'm not saying the numbers are definitely going to go here, but from a budgetary perspective, from a planning perspective, if you're investing in your people and your operations over the next 5, 8, 10 years, these are some of the numbers you need to consider when you're looking at growth. And this is just the regular stuff for overtime. Now, let's take a look at those highly compensated employees, because in 27, here's where they could be if you pull the same percentage straight through. Now, admittedly, I recognize it wouldn't always be 2%, but for the purposes of what we're talking about here, it allows you to take a look at where we might be come 2033. Presuming there's no change in what the final regulations have already said. I'm imagining that you're probably already thrilled. So let me see if I can dial this back a little bit and give you less heart palpitations by thinking about what occurred before that I mentioned when we first started talking together today. You see, before the last time we went through this with the Department of Labor and the overtime threshold, that litigation that took place in Texas, there were a couple things they looked at, and because of that may impact what is happening today. You see, there is an argument to suggest that actually the Department of Labor has overstepped their authority, that by picking percentages and changing percentages and putting in an automatic escalator, that they are making the salary information more important than the duties and changing the balance of where things stand. The automatic increases are particularly problematic. Obviously, you could tell that from the slide before, but that's not all we need to be thinking about, because there's another piece that you may or may not be aware of. And to be honest, unless you're a bit of a political egghead and pay attention to these things, right now, we actually have an acting secretary for the Department of Labor. There's some question as to whether or not they have the authority to do what they're doing right now. And again, it depends on your perspective in terms of how this works. But here's why all this stuff matters and why you really need to be paying attention for yourselves immediately. And the reason is this: there's only 60 days before this puppy is supposed to come into effect. And so I hate to tell you, we could go on and on about different options, but at the end of the day, the major concern is this is not a small lift. For those of you that did this back last time around or at any point in the past, you know that this is a heavy lift. It's something we're already dealing with clients, trying to make sure that the numbers all work out, just in case. Now I'll get to that in a sec, but here's a list of some things you're going to want to deal with right now as it relates to overtime. The first thing, of course, is those pesky job descriptions. What do they actually say? What are the actual duties that people are doing? I know, maybe you've taken a look at them, maybe you haven't. Some of you looked at the classifications, some of you didn't, but this is a great time for you to sit down and take a look at those job descriptions. I got a bunch on my desk right now that I'm going through, because at the end of the day, that's going to drive a lot of what happens. And so we need to make sure that they're current in order to address some of the issues financially that exist for your organization. Additionally, we have to take a look at the practicalities within the HR space. And what I mean by that is this: many of you, and in some jurisdictions, you're required when you post to put in a salary range on a job posting. And so if we take a look at all the different, on a whiteboard, let's say, and we were to put up all of your different titles and the different salary ranges, what's this going to do? It's likely going to create salary compression, which is not necessarily a good thing, right? I mean, whatever the CEO makes, nobody's going above that, right? And so as we continue to push up on the floor, we're bumping up against everybody, and it's creating a challenge that isn't always appreciated by everyone in the organization. But I think we can agree it makes it much more difficult, particularly as you're trying to move people from, say, rank and file into management, because if that delta is too small, the argument may be, well, heck, I don't want to do that. I want to just stay doing what I'm doing right now. Similarly, there are a plethora of handbook and policy issues that get impacted by deciding, well, are you overtime eligible? Are you not overtime eligible? How are we doing time? In what way are we addressing the concerns? How are we making sure that you don't inadvertently work at times we don't want you to work because of your status? What if they're remote? What if they're hybrid? How are we calculating these things? Once again, this is an opportunity to sit back, take a look at these things. Again, still something that we're dealing with right now. The opportunity to go over handbooks and through the policies are particularly challenging right now. And this is no different, just that we're staring down a deadline. And so we're trying to figure things out. Oh, but wait, there's more, because we also need to think about how we communicating this to employees. I've often shared the story where I went in for a client who wanted me to go in and tell a group of nurses that they were misclassified and that they were going to be overtime eligible. And I went in, they had me meet in this practice in the waiting room with all the staff and brought in pizza. And then I'm the guy that walks in with my trial bag, and I put the trial bag down. And now I've got to explain to everybody why, oh, by the way, I know you like the fact that you're salaried, but guess what? Now you're going to be overtime eligible. And I was waiting for a piece of pizza to come flying at my head. Now, thankfully, that did not happen. But here's why that matters. Because so much of this is about having that conversation with your employees so that they appreciate what's going on. It's important if they understand the why, then however you phrase it may not be problematic. But when we start looking at the escalator, if that sticks, these numbers are going to get big quick. And it may mean that certain people you otherwise would not have made hourly or overtime eligible are going to end up there. And so we need to have those honest conversations that, look, it's not about us. We don't want to do this, but it is what's getting driven by the government. But wait, there's more. There are a couple of other things we still can also consider. For example, maybe part of this is an opportunity to take a look at how you're tracking time. Do you need to track time differently? Are you doing it correctly now? Remember, at the end of the day, whether it's a wage and hour issue or some other concern that comes up where you're ending up calling your employment attorney, what the first thing we're going to say is, listen, you need to appreciate the fact that the problem here is, employer, you are obligated to know the time. Whether the employee agrees with you or not, the record keeping component is our responsibility. And so as we evolve, independent of whether people are remote or not, we got to make sure we're properly tracking time. Additionally, listen, there may be, and honestly, I've already done the talks on AI, but how we staff things and what AI can do and how they can cut down on the amount of time to do one assignment or another may be beneficial. But taking a look at it in a whole new way, if you're concerned about folks who are now overtime eligible, who may be able to utilize AI to shorten the amount of time or the closeness with which they will get closer to overtime. And so all of a sudden, this investment in AI or other tech may change slightly that you're going to want to think about now before you end up with a payroll portion of your budget that is much more challenging to address than it is today. At the same time, there is something to be said for the fact that some folks, like those nurses I went and met with, want to believe that they're salaried employees. They take pride in that. You know, we talk about the whole culture component. That's where this is, right? Like they believe this is, it's part of who I am. It's what I do. Here's the challenge that we need to address. At the end of the day, and for those of you that have chatted with me else in other scenarios, you know that I talk about this a lot. I don't care what you tell them that they are. You can say that they are salaried employees and still pay them overtime. Because at the end of the day, the Department of Labor doesn't care what you call them or what they say they are. All they care is how you pay them. Now, it may be as simple when we go back up to number one here. Well, everybody's going to track their time. And then what we figure out is those of you who are overtime eligible, you can say you're salaried, but we're still going to provide this to you. All right. Either way, we have to make sure that the pay portion is done correctly, independent of what we call them, recognizing that the culture and morale is impacted by how and what we say to our employees. Lastly, there is a world where we may even need to take a look at either doing a SWOT analysis or other long-term budgeting reviews in order to assess how you're going to deal with this beast. Whether it changes in July, whether it changes in January, whether it's got that escalator, these are the strategic things within your organization you need to consider now before you end up in a situation where you can't afford the overtime that your employees are actually billing. So let me ask, in a word, what are you most concerned about regarding the regulatory changes to overtime? Just kind of curious. You know, early on in my career, I would have said that compliance is a bad word. Clearly, I'm eating crow. Now, there are a couple of things about this that I do want to make sure I mention. Obviously, a lot of these issues remain active concerns as it relates to overtime. But here's another piece for you to consider. When we start looking around at different things, for example, the travel, okay, and the budgeting piece, there are ways to address these and to get much more granular. Again, these are some of the things we deal with all the time with clients, trying to appreciate, well, we used to deal with it this way. Well, maybe because of all these changes, we need to address our situation in a very, very different way now. And that's not a bad thing. But again, it's all about communicating to our employees about what matters, what's important, and why we need to be so concerned about what we're doing prospectively. So thank you for sharing. All right. Now, I know you're saying to yourselves, so what's the litigation that people have already filed for overtime? Friends, if there's anything in putting this entire thing together that has driven me insane, it is this slide. I was hoping that I wasn't going to have this picture for you. I was hoping I was actually going to be able to give you, here is the litigation that's been filed. And you know how much has been filed? Nothing. Now, on a certain level, that scares the out of me. But maybe it's a good thing. Maybe it's because people are planning more. I'm not really sure. But for all of you that think, well, I remember what happened last time that Texas did X, Y, or Z, that's great. But you know what? Remember who sued last time? Yeah, they're focusing in other areas. I mean, maybe this was part of the federal plan. I mean, they dropped so many things at one time that the U.S. Chamber of Commerce is running around like a chicken without a head, trying to figure out what to do. But as of right now, as of May 23rd, no one has filed litigation yet, not on the overtime regs. So stay tuned and pay attention to the news. I know that seems like an oxymoron these days, but it is a concern because right now, all this stuff is going forward at the moment. So let's try and find a different way to address some of the other concerns that we might have, because at the end of the day, it's not just about overtime. It's also about an organization you have probably heard next to nothing about. You see, before we started talking about background checks, did anybody really know in the employment space what the FTC did? Honestly, I'm not even sure right now that I really necessarily know, but be that as it may, I'm sure that the two questions on the screen behind me are exactly what you're thinking right now. And the reality is, I will give you the lawyer answer, which of course is, it depends. It depends in part on how you look at it, but perhaps let's look at this from your perspective as opposed to from my perspective. And let me ask you a question. Okay, what is your biggest concern as it relates to the non-compete issues that we're dealing with right now? And as you're filling this out, there is another item that I want you to think about. And it's the fact that remember your employees, whether it's the C-suite all the way down to the janitor. And I say that because in some organizations, they've had them sign these things. There's going to be a lot of education that has to happen here, whatever ends up happening. And I'm going to explain that more in a minute. Now, listen, for those of you that have, for anybody that answered E, okay, I would ask, please put into the chat what that other concern is, and I will try and address that either now or as soon as we're done today. All right. With that said, let's hop right into the fun in a bit more of an intentional way. Because if we're taking a look at just the facts, of course, we've already dealt with the overtime stuff. So we're going to put that on the shelf for a sec and look at the fact that this is all about one thing, the day before my birthday, September 4th, whether or not this stuff is actually going to happen then. According to the 500 plus pages, it's not just about when the effective date is. It's also the fact that this is not impacting every organization. And I think that's important to keep an eye on. Because in addition to that, we also have the fact that there's this notice component. And it's interesting how they've done that. We'll talk about that as well. And in addition to notice, senior execs are being handled in a very different way. And of course, that comes up because I don't know about you, but at least in our practice, we're getting plenty of folks either representing the company or the senior exec who's saying, hey, how does this impact me and the work that I'm doing? Or how do we address our senior executives and make sure that the documents are actually appropriate? Well, it's a work in progress. Appreciate the fact, though, that allegedly this is going to preempt state law, right? This idea of whatever's more protective for the individual employee under the category that you really can't make this stuff up. Now, I want to make sure we're all on the same page because I think that some of my brethren have done a disservice, or as organizations, we've done a disservice to our employees. And the reason is there's been a lot of blurring of the lines of what things mean. According to the FTC and the final reg as it relates to non-compete agreements, the definition for non-compete is right here. Now, most of you may know, I am not about putting all sorts of text on a slide, but this slide is arguably in this space the most important thing for you to keep an eye on, because here's the situation you need to appreciate. As we go forward, the assessment by a court or the FTC around whether or not something violates these regs is all going to be based on this definition. So something for you to ponder. Again, as I said, I have the opportunity for you. We're going to go through. I'm going to give you the chance to get the slides, and as I'm trying to up my game and the work that I do, we'll get to that. But I did want to make sure that I flagged for you this particular slide, because it's, think about it, right? It's all about competition and allowing someone to leave and either go work for somebody else or for themselves within the same space, in essence. At the same time, there are other concerns that relate to who is not covered, because again, as I mentioned before, this isn't everybody. In fact, consider all the areas that are not covered. Now, of course, the best rule has an exception, right? Don't forget, even if you're a nonprofit, there are still a plethora of parameters that have to get, boxes that need to be checked before you're truly exempt as it relates to this area. But I wanted to make sure that everyone saw the fact that this doesn't cover everybody. Now, we can get into this whole cultural discussion about, well, what's the best place to work, and how do we find the most efficient use of our time, and how do we keep employees? So just because someone or some entity may be outside of these regs doesn't necessarily mean that you're not going to have to deal with it, because why would people come to work for you if they can go somewhere else and not have the restriction? Little food for thought there. In addition to that, I do think there's something to be said for the fact that at the end of the day, this really is about how we convey things to our employees. And to the extent that this doesn't get the big kibosh, there is a need to provide notice. Now, this is a picture of the notice that's provided within the regulations, and you can easily find it at the FTC site. And there are 4 ways that you can provide notice to your employees at some point, but not after the effective date, which currently, of course, is September 4th. You can give it to them. You can literally hand it to them. You could also mail it to their last known personal address. And we can get into that, right? In a post-COVID world, when people moved all over the place, do you actually have the last known address, and did they have to give it to you? That's a whole other conversation, because you could also do it via email. Even if it were a mass email, that would be fine. Or, surprisingly enough, you can also tell them by text. However, I am all about protecting my clients, so I'm all about also protecting all of you. Here's what you need to think about. Ready for this? Think about the requirements. Oh, you're going to love this. Of the WARN Act. Remember, 69-day notice in writing ahead of time that you can show before you close down, get rid of a bunch of folks, and move on somewhere else. I mention this because at the end of the day, however you provide notice, it may be that somebody has some issue with either the notice or whatever the parameters are prospectively after the effective date. Rather than ending up in litigation over it, I would impress upon you to make sure you have a list of who you provided the notice to, no matter what of the 4 options you avail yourselves of. Oh, and the other thing you should be aware of, there are actually 7 different languages that the notice has already been prepared for, so that allegedly your workforce can read it in their native language. Those languages, of course, just so you know, are English, Arabic, Korean, Chinese, Vietnamese, Tagalog, and Spanish. In case you're wondering. But again, I think it's really important for you to make sure that you keep those and have that information for you. I mentioned before, there's another challenge with all of this stuff, and it's how we're dealing with senior executives. So just to be clear, if you've got a current senior executive package where they've got a non-compete agreement, that's fine. If it doesn't change, they don't sign a new one, you're good to go. However, after the effective date, that's it, right? Not as, at least as it relates to a non-compete. Sometimes that's a big deal, but remember, it's not just, how they're getting paid. It's also making sure that they have policymaking authority. And again, like the other scenarios of exemptions, this gets to be a very fact-specific discussion. What I would take away from this slide is this idea that if there's stuff that already exists, if you don't change anything, it's perfectly fine. All right. Now, by the way, some of the issues around here and why we're even here is because hairdressers, baristas, sandwich makers have all been asked to sign non-compete agreements. Whether you think that's right or not, that's what's been going on, and that's what has driven the FTC and the federal government to go here. But it's not just the federal government. But before we get there, let's step back for 30 seconds. And let me ask you, how many of you, well, when was the last time, in fact, you took a look at those job descriptions? Have you done it recently? Maybe you're thinking, we'll get to it eventually. Let me know. And Judy, I'll tell you that that is a very fact-specific assessment that is very technical. I'm happy to provide that to you, but it's not as simple as just saying we have a tax ID exemption. It is a more thorough analysis, at least according to the FTC. Now, when you take a look at where you fall on this list, one of the things I want you to keep in mind is the fact that, remember, the job descriptions are going to drive the opportunity, not just for the non-compete, but also for the overtime regulatory potential changes. All right, let's keep going. The biggest difference between the overtime stuff and the non-compete information that we've been talking about is this, friends. There's some active litigation in this area. Regrettably, I didn't file any of it, but here's where we are. The first two cases are from, shockingly, Texas. Ryan is a tax entity that works globally. Oh, but wait, there's more. In addition to that, the U.S. Chamber also filed. Ryan filed a day before the Chamber, both in different portions or places within the state of Texas. Now, the reasoning behind what they're doing is the same. And so the question becomes, how does that all work? But basically, they're saying that the regulation violates the U.S. Constitution, that it goes beyond what the FTC legally is allowed to do under the law that created the FTC, and that what they're doing is arbitrary and capricious, as well as the fact that under the Chamber case, they also sought an injunction to stop it, basically saying, listen, if you allow this rule to go into effect, unraveling that later is going to be a problem, because what does that do to all the agreements that are currently in place? And so all of that stuff is pending. In fact, it's currently being briefed. We are anticipating that there will be some type of a preliminary determination come early July. So stay tuned. Again, it's all a very fluid situation right now. In addition to these two cases, there's even one closer to where I am right now, over in the Eastern District of Pennsylvania, ATS, which is a tree service, basically on the same bases that Ryan and the Chamber did. It's just that they filed it in the Eastern District of Pennsylvania as opposed to Texas. We'll see where all these things go. I would anticipate that they're all going to end up tracking to some degree. Otherwise, of course, if there's a distinction between the circuits, it'll likely end up with the U.S. Supreme Court if that becomes necessary. So I share that with you to say, just because we're talking about all this stuff doesn't necessarily mean that the federal non-compete stuff is going to go away. But there's another wrinkle here, friends, and we haven't really talked about it at all. And so I'm going to talk about it right now, because there are not one, not two, but 4 states that currently prohibit non-compete agreements, period, beyond what the FTC is doing, because it covers all the organizations within those states. I've starred them for you here, but here's what becomes important. The FTC looked at these 4 states and said, well, heck, if they're doing it without a problem, then we ought to be able to do this without a problem either. Of course, even if you're in places like a New Jersey, for example, what you find is that these restrictions still need to be reasonable in duration, in amount, in scope. And so there's still some amount of play. But I raise this because even if this stuff gets the kibosh because of the litigation that's going on, I think we're at the precipice of something changing very significantly, which still means you need to take the time to take a look at this stuff in a very, very intentional way right now, because it's not going to stop here. And it's likely, right? I mean, what ends up happening if the minimum wage changes at the federal level, all the states get in line too. I think this is another area like overtime where I would expect these things to continue to happen. Now, you may not pay a whole lot of attention, but I can tell you that we do when we're doing this stuff for clients. But in the agreements that we draft, there's a provision that you should be aware of, because words do matter. And in particular, this particular section, because severability is in most of the agreements that we do. And in essence, it says, if we're thinking about it in micro terms, if any part of this agreement is determined to be illegal, inappropriate, whatever, you just throw that out, but it doesn't negate the rest of the document. Now, you may be looking at this saying, well, heck, if I have a non-compete in an agreement, who cares? It doesn't really matter because this section will just pop it out. Here's the problem. As I mentioned earlier, we've been doing a disservice. And what I mean by that is this. When we think about next steps in space, we have to be pragmatic. We have to understand how this is working, because there are other provisions that touch on similar areas. For example, the FTC is not precluding non-solicitation agreements unless it impacts the non-compete definition that I showed you on a slide a few minutes ago. And so figuring that out, okay, well, is it just not soliciting other employees? Is it don't solicit clients? How does that impact? And so you can quickly see that this is a much more involved assessment, a much more detailed review. This is the kind of stuff that we're doing right now. Taking a look at stuff for clients, looking at the verbiage, because while it's okay on its face, that doesn't mean that the verbiage you're actually using is appropriate. In fact, if it's not a non-solicitation, it might even fall under an NDA. You know, some people have information they don't want out that's somewhat private, and they have someone sign an NDA before they ever come in the door, just to even talk about something, the technical stuff, right? The non-public stuff, the things that are valuable to the organization that if it got out would be a problem. Again, the FTC regulatory changes don't negate this so long as it doesn't adversely impact the non-competitive components we talked about before. In addition to that, if you're thinking more like trade secrets, if you're thinking about copyrights, trademarks, okay, those kinds of things, similarly, we can still protect. It's just we have to think about what verbiage is in that section and how does that work. Additionally, we also have to look at prospectively, right? Once this goes into effect, we still deal with the senior exec agreements. And so what are we putting in place to try and protect the organization as they come in to run the organization? So all of these components are issues that you need to take a look at. And I would argue issues that you need to take a look at now. And whether we're talking about the overtime concerns or we're talking about the non-compete agreements, we also need to think about what this means, right? Remember the 3 circles I talked about. When you look at it from the perspective of competitiveness, as well as from a cultural perspective, we have to think about what our people are doing and how they're getting stuff done. Meaning, there is a need at this point to go back and have some of those discussions, and not just in an email, so that people understand and appreciate what the new overtime situation is, how we're calculating it, and how it impacts everybody else so that we can be more efficient. Are we utilizing AI? How are we utilizing AI? How can you work? How are we looking at travel time? How are we looking at the different aspects of your daily operations? And it's probably different. Remember, we've got 4 or 5 generations, depending on your organization, working right now. And this is the way we used to do it may not work as these things come into effect. And so we need to retrain, reinvigorate, and have everybody be on the same page. But it's not just wage and hour, it's also taking a look at, well, what are the policy differences now? How are we changing? If we can't have the non-compete stuff, how does that impact confidentiality concerns? How does it impact the non-solicitation? And get really specific, meaning your workforce needs to understand what non-solicitation means within your organization. If they're going to go and leave, how does that impact what they do prospectively? What is it that you really need to protect, right? We talk about a true trade secret. In my mind, we're thinking about, the formula for Coke. We're not talking about a list I could just generate off of Google or ask ChatGPT to create, tell me my top 5 competitors, right? Because one would argue that's publicly available. And so the issue of this line becomes a big deal, right? Because let's be honest, whether I'm working at Dunkin' Donuts or whether I'm working at Starbucks as a barista, is there really any difference? Like, why did I ever sign a non-compete in the first place? Little things, but again, it's all about how we educate our people. In addition to that, there is a concern. Remember, all of these laws include components of retaliation. They include this idea of don't be harassing folks. And so there's a world where people get upset around how they're paid, and it takes you down a path that you want to be concerned about. By the way, in addition to the 2 areas we're talking about today, maybe this may have been glossed over, but the EEOC recently came out with new anti-discrimination thought processes that also ought to be incorporated into the kinds of things that you're talking to your employees about today and into the future. I would argue even more than all of this is the need to very intentionally sit down and work out stuff with your managers, meaning that they're the ones that have probably been there the longest. They appreciate what's going on, but here's the problem. They're going to presume, well, this is the way we did it, so this is how it should be done. And that may not work, as I said before. I just don't think that we can approach this the same way that the workforce is changing based on AI and its implication in the workforce and the workplace. We also have to be thinking about what does this mean and how is it going to impact our bottom line? You can't look at the numbers and the escalator potential and not think to yourself, geez, I'm really not sure what to do, but I have to figure it out. Now, friends, I've spent some time with you today, and I really appreciate you taking the time. I want to ask if you'd be so kind. Here's what we're going to do for a moment. I think if you could take your cell phone, open up the camera, point it to the screen, okay? That would be really helpful. And what you can do is you can put it in it'll prompt you to go to a link, all right? And if you hit that link, you can actually provide some feedback on today. And by the way, I have some other closing remarks, but I want to have you take the time to fill this out first. And if you are having difficulty here, I put into the chat the link as well, which you can do that way if that's easier for you. In fact, I'll pop it in one more time here because I think I didn't necessarily do it the right way, but there you go. And then I'll give everybody like a minute or so or 2 minutes to fill this out. And then I'm going to give you my closing thoughts. All right. Because there's still a couple things to cover. Want to make sure that everybody has the opportunity to sort of ponder some of the interesting things we've been talking about today. And I greatly appreciate you taking the time to fill this out, because for me, it really helps me to level up what I'm doing, what worked, what didn't work, ways that I can improve and provide more for you prospectively. Now, by the way, when you finish going through the feedback, you will have the opportunity to download the slides from today. And in the back of that is the cert material for the SHRM PDC if you need that as well. I know we're going 1 minute over, but I promise I'll be done in 2. Not a problem. All right, for those of you that are finishing up, please do take the time to finish up. And I'm just going to provide to you my closing thoughts as we move forward here. As I mentioned to you earlier, there are really 3 critical issues that get dealt with through all of this. We've talked a lot about the calculations on the overtime components, as well as the non-compete issues. And the concerns, of course, around the non-compete are, if you're investing all this stuff into your people, how does that impact your bottom line, and how do you further protect yourself? Which brings on a whole other way of looking at the calculations from the perspective of your organization. But often lost in so much of this is the issue around culture, and how all of this impacts the work that you do, and how important it is, not just for your organization, but for every one of the individuals that is touched by your organization, either directly working for you or their families. So I want to encourage you to think about the transparency that you need with your employees, as well as their morale and how they're going to look at, am I overtime eligible? Am I salaried? How does this work? How do I do things prospectively? Because they're going to look to you as the organization to set the tone. I appreciate what many of this, or how these things will impact your organization. And I want you to appreciate the fact that from a competitive perspective, look, if we're all in the same boat, then we're all dealing with it. The question becomes, what does it all mean? And that's the stuff that we're going to have to wait and see. However, we know that there's already litigation on the non-compete, both in Texas as well as in Pennsylvania. Stay tuned to hear more about what happens as it relates to the overtime issues. What I think is critically important, and I hope that I have shown you today, is the fact that whichever circle you're most concerned about, or maybe you're concerned about all of them, what you need to be most thoughtful about is that both of these issues are things you need to address today. We're already sitting down with our clients dealing with this stuff. So please do take the opportunity.
Yeah, and you have a prescription ready at Walgreens. I think it's your albuterols.
Okay.
All right, let me just do one quick thing here.
But you're not taking the van.
No.
All right, I took care of that. Sorry, sometimes people unmute themselves. But I just want to thank you all for taking the time to join me today. I hope you have a fantastic holiday weekend, and do take the time to think about all these things. If there's some way that I can assist you, or another member of our firm can assist you, please don't hesitate to reach out. And otherwise, I want to wish you a very, very wonderful holiday weekend. And thank you so much for joining me today. Take care, everybody.